Hello, everyone. Welcome back to the channel. Tony here with Italian Dual Citizenship Assistance. And in today's video, I'm very excited to be joined once again by a very special guest. Our previous interview was wildly popular, and I've received many, many requests to have him back on, as well as many clients who've reached out and who have opted to work with him to file their Italian citizenship court cases, and who have reached out to me to help them get clear on their eligibility and options and prepare their documents for the case. So welcome back, Avvocato Arturo Grasso.
Johnny, thank you for inviting me. It's a great opportunity to talk to you and to the all people seeking for advice and where we are. Grazie mille, grazie per avermi invitato.
Now, for those of you who don't already know him by reputation, Mr. Grasso is widely known as one of the very top Italian lawyers in Italy when it comes to Italian citizenship by descent. Mr. Grasso himself is an immigrant to Italy. He was born in Germany to immigrant parents, and this fact is evident in all of the great work he does for those seeking Italian citizenship by descent and those with Italian ancestry born outside of Italy. So thank you for all you're doing for those seeking recognition of their Italian citizenship by descent, Arturo.
È una missione, it's a mission.
Well, like I said, our last conversation was extremely popular, and I think it was very well timed. There was a real lack of information out there at the time. So I hope we can deliver that again for people and just really inform people. This is a great time to have another conversation. We're really at the crossroads with a lot of things happening since we last spoke. Notably, we've seen decision 142 of the 24 June 2025 case published on July 31st. We've seen the June 25th referral to the Constitutional Court from the court in Turin, and the Supreme Court decision to examine the minor issue. So why don't we start with decision 142 from that June 24th, 2025 case, which was published just a couple of weeks ago back on July 31st. What questions does this decision address, this so-called Bologna case?
The legal background and the legal argumentation, right? The arguments right now have become very complicated. You know, when before March 28, citizenship cases were all about putting together documentation and explain the judge in a court case where those documents were. Every judge was aware about landmarks, decision, which they could apply themselves. We explained, but they knew. Every judge knew. Now it's become very complex to explain current situation, what is not constitutional according to the judges, according to the scholars, why there's a lot also discussion about evidences, what kind of evidence we need to bring in court. And it's really complicated. So it's good to talk to them and explain how complex it is, at the same time, what we expect to come in the future. Yes, ruling decision 142 from the Constitutional Court is another landmark decision. When this happened in the end of November last year, when the judge from Bologna deferred the case, it was a really shock to everyone about what was going on with this court, why the judge was asking for if they should consider only two generations, or if they should ask people if they spoke Italian and so forth. And everyone was really wondering if they should prove that they aim to come to Italy, to visit Italy and so forth. We had clients asking us, oh, but by the way, I come every year. Would you say that to the judge? Asking things that they were never written in the law. So everyone was trained. And so we were waiting for this decision, but then before this, we had the decree law. So we were aiming at that point that somehow the Constitutional Court would also give us a hit, something to make us believe how they were going to rule in the future. During the hearing before the Constitutional Court for the Bologna case, there was also an attempt to say, why don't you vest yourself of the whole matter, and you include also the decree law. But the court didn't take this approach. She specifically, expressly dismissed this approach and said they were not going to do that. So what does this mean? What was the outcome from the decision 142 of June 24th? The decision was that the court could not really make any change to the law because it was too, the changes request were too wide, were too much, and after all left to the parliament, because only the parliament can make such a wide decision and say how many generations. If someone to become Italian needs to speak Italian, so or needs to live in Italy, what's the difference living in Italy and living abroad? Is such a wide question and so many conditions to request that the court could not really address. And she specifically said, although I can decide on a citizenship matter, this is too broad questions, too many questions and too broad, which only the parliament can assess. So the court didn't give any answer, said dismissed the case and said, I cannot, this is something which is the lawmakers should do, not the court. What does it mean in practical content? All cases filed up to March 27, no more issue, no more question about language. Oh, attorney, shall I speak Italian? I'm proficient in Italian. Doesn't matter. I'm 3 or 4 generations. Doesn't matter. I come to the league. Doesn't matter. The judge needs to rule the way they did so far, just by considering if someone is the son of an Italian parent. That's all. No more evidence or questions. Nothing to prove, which is very important because somehow the court at some point could say something about this. And we were a little bit, there's always some slight fear that the court may say something which is out of topic. And but there's nothing. The court didn't address any of those questions and said they all dismissed. So nothing, no fears for whoever's already filed before March 28. They must be decided according to the past law, the way it has been so far up to March 28. What the left question is if this decision is going to address anything for the future on the decree law 36. Though that was something every attorney was expecting and say, is the court going to say something in this 26-page, I believe, of decision where you can grasp something and believe this is going to be the future approach from the court? It's really hard to say. In so many pages, there might be 1 or 2 comments which may make us believe the approach they're going to take. A couple of lines, no more than this. But the most important one, there are 2. One on page, in my opinion, page 13 and page 16. The first one, the court says in a couple of lines, citizenship is always being considered by courts, not just constitutional court, but by courts, by the Court of Cassation, the third, level of justice in Italy, or by courts of merits, so first instance court or appeal court, that citizenship is all about being the son of your parent. So it's all about parentage. It's all about that. The parentage itself, the line. It's true that in a case of from today case from Italian descendants, there are multiple level, multi-generation. But in reality, you should consider just each fragment of that generation. So parent and child. Is that child really the son or the daughter of that person, of that mother, of that father? Was the mother, father Italian? Yes, that's all about it. No more than this. So that makes us believe that the court approach, at least for cases of people who were born before March 28, would be assessed just in the same way they have been so far. I mean, just like the Bologna case. They children of an Italian parent, and that's all about it. There's nothing to inquire, discuss more than this. Not about language, test, and especially if they fired or they did not fire, because the recognition by the consulate has never been considered a condition for citizenship. It's not naturalization. In the naturalization process, you go through the Italian administration, they make decision, they make evaluation, they consider even Italian national security, and then they say, yes, you can with a proper decision, which is a degree most of the time. And after that you take a note. That's an administrative process where the consulate has something to say and to make decision. But here, there's nothing all about this. It's just about asking the vital record registrar to register birth and marriage certificate, especially birth, and consider if the child was a child of an Italian parent. That's all about it. So no more consideration to this. This is number one. And the second place where someone could see a landmark for future decision, which we're going to talk in more surely later, is that the court said, of course, the parliament can do the law the way they want it because they're free to decide if you need language, if you need test, or if you need being in Italy for how long and so forth. But the Constitutional Court is going to review this in the light of proportionality, equality, so the principle of Constitution. So you can't make something which is disconnected or just not needed, or too much, even too much sometimes. So this is the light the Constitutional Court is going to use. And they already said that. So the parliament is free, but we are going to review the whole, whatever they decide, in the perspective of the Constitution, on our Constitution, Italian Constitution. So this is the two, basically, which I believe matter for the future.
Okay. Well, thank you for that detailed description. A lot of people have been really trying to figure out what this decision means. And I don't think a lot of people realized that this Constitutional Court case was one that pertained to a pre-decree case, not a direct examination of the decree law or the subsequently converted Law 74. So this case was more looking at things from the sort of opposite end of the spectrum than most people who are interested in Italian citizenship by descent would like them to be looking at it. The judge in that case said, I don't think this unlimited number of generations that we're currently using in our concept of ius sanguinis in these cases is constitutional. So the Constitutional Court was looking at it from the wrong perspective that most of us would say, right? We want to see it stay an unlimited number of generations, but ultimately the court decided the unlimited number of generations is perfectly constitutional.
It's not an issue. Of course, the parliament can change that in their view, but again, it has to be in a way that makes sense, and especially not depriving people if they're already born and they were born as Italian, because they got derivative. It's a derivative citizenship from parents. So they got at birth. And birth if they parent is Italian. So you can't go back and say, if someone is born abroad and does not made so far show up so far, it should be deemed as they never become, because you can't go back in that way and deprive of a fundamental right. So they say, will the court say, if the parliament say unlimited, the 2-generation limits, is that too much or has to be cancelled? The court didn't say we should wait for such a decision. So though it's constitutional from in the previous law, we should look at the next law for the future generation, what it means for future generation. We're talking about whoever was born after the new law, the decree law. So so surely, so far, but we're going to talk, I'm sure, about this, that's not a question brought before the Constitutional Court. The limit of generation to 2 generation. That's an anticipation of that. Yeah.
I've seen a lot of hyperbole being used about this July 31st decision, saying that this is going to change everything. And, it doesn't sound like you think that that is necessarily true, at least not yet. At best, they're showing us maybe how they're leaning in the Constitutional Court and maybe setting things up for how the subsequent case, the Turin case that was referred to the Constitutional Court on June 25th, how that case might go. That one obviously sounds like has a lot more potential for impact than the June 24th case.
I mean, the judge in Torino, Judge Alessandra, made a direct question to the Constitutional Court and said, it's the only one actually. He made one question. When the decree law was first written and announced by the ministry, he had several issues, but they were able to make it worse. There were even more issues. And I cannot say the numbers, but there are several still to be decided by the Constitutional Court and perhaps even later by a court of merits to see what was the approach to some of these legal arguments. But among so many, one of the major one was, can really the decree law deprive all people that so far have not shown up? But there are maybe couple of millions or some millions out there that really care to become Italians. And they were born before March 28. And they were children of Italian parents. They didn't tell any time to the consulate that they didn't need to go to court, but that doesn't mean they didn't want to, or it doesn't have any consequence on the parentage, which is the only connection to become a citizen. So if you're the son and your father was Italian or your mother was Italian, and you're the child or the daughter, son or daughter of an Italian parents, you're Italian. That's it. That's the law. But they can add this condition by not mentioning to the consulate or not getting an appointment. What's an appointment? What do you mean with an appointment? What effect could ever have an appointment on a citizenship fundamental right? Nothing. So most probably the Constitutional Court, with the Turin case, and that was the question really brought by the Judge Alessandra. The question the only one question he made so far was, is it possible that a law like Decree Law 36 can ever deprive people of their citizenship just because they didn't show up, didn't mention anything, or didn't come to the consulate while they were already born? That's the question that he made. Now, like it happened with the Bologna case, this is going to be published on the Gazzetta Ufficiale, and then it's going to be get a hearing. Has been already published. It's going to be having a hearing, set an hearing date, and other judges from other courts can add, if they want to, other questions for the court to be vested. It might happen like it did with Bologna, because Bologna was the first, but then also Milan sent another piece and for Firenze first, and then Milan and Roma. And they had questions like, the judge in Bologna only said law 91 or 92, and the other one said also law 555 or 1912. And they also had the Civil Code of 1865. The court dismissed those questions, and they said only law 91 or 1992. But what I'm saying is they can add. So we can expect to have more questions brought before the Constitutional Court by the time of the hearing.
So let's dive into this Turin case a little bit further. I want to understand the possible timeline.
I'm proud that we made a post before the hearing of the Constitutional Court and the deferral. The next day, the hearing was on the 24th. You mentioned that, and the 25th was the deferral. I'm proud that we made a post sometimes earlier by predicting that there was going to be a deferral, specific deferral of the decree for the decree law, which might be decided by spring next year. And I'm still in that kind of scenario. So as a timeline, I'm expecting that the Constitutional Court would set a hearing for the spring next year. But it was easy to make the calculation because what happened with the Bologna case was deferred by the judge in November, the end of November. and the hearing was set for June. So I expect, if you make the same calculation, you just need to consider that August, the court doesn't work, and any court works, so that's it's not just next month.
It seems like the whole retroactive application of this law, is sounds like a fundamental issue here. I've heard a lot of attorneys say that they don't believe that this law, which retroactively strips people of as essential a right as citizenship based on the laws at the time that these people were born, will ever hold up to all of the legal and constitutional challenges going on, and that eventually this law will only be able to apply to people born on March 28th or later. What do you think about that concept? Are you in agreement?
Basically, yes. Since the very beginning, then there were hearings in the Senate before the commission with scholars, and everyone said, this is a scheme of labels, because it looks like you are depriving people, but you not mention this clearly in the law, but you are depriving people of their fundamental right, because even the president from the court, the past president from the Court of Venice, with thousands of cases, 40,000 cases in court, he said, and you putting the condition for them into the recognition before the consulate of they've been before the consulate, but that has never been a condition for that. So you're depriving. You must be aware that you're depriving, and the condition for depriving is something which has nothing to do with the right, with the citizenship right, which is a birthright. And so nobody really agreed. But then they moved on, and then they passed a law in this the way it was, basically with this concept of deprivation. They just added the appointment date. But since then, we have this decision from the Constitutional Court with a couple of lines that I just mentioned earlier at page 13, saying citizenship has always been a matter of parentage, being the child of, there's no extra condition. So they get by birth. And you can't really, it doesn't say you can't deprive. The Constitutional Court doesn't say that. They just stop at where they say citizenship has always been, in any court, a matter of parentage, being the child of an Italian parent. That's all about it. The fact of being a relation between a parent and child is a condition to become a citizen, if the parent, of course, still holds a citizenship. That's all about it, no more than this. They didn't go further and say, so you can deprive. But in reality, if you consider this, and there's also another passage which a famous scholar from Padua has commented about the Constitutional Court decision, the 142 decision. And it's about when the court discusses about the European Court of Justice, where they mention because Italian citizenship or any member state citizenship means also having a European citizenship. So the European Court steps in and says, because of you can't decide the way you want to provide citizenship, but once someone has it, you can just deprive them in the way you want, because that means also depriving European citizenship. So I have to say in this, my say. And the court said, when someone does something like this, you need to provide proper consideration and treat each case individually and give an opportunity to them to say, yes, I want, or no, I don't want to, I want to keep it. That's not fair. So individually, consideration for cases. You can't just deprive a large mass of people in the way it's done. So I'm expecting that the Constitutional Court is going to look at this with proportionality. So this is not a proper measure to deprive people in such large, indifferent, without proper individual consideration. And it might be, it looks like the court is going to say, and the court mentioned this passage, said the European Court of Justice doesn't like this, such a deprivation of large mass of people, not without individual consideration. Today, we have a couple of more landmarks or stones where we can put our foot and say, look, the court said that it's a birthright and has nothing to do with being recognized by the government or show up to the government or acknowledge the government. And the Constitutional Court said, the parliament can certainly do the law and say how they want the citizenship to become in the future. But I'm going to look into that and decide also from a constitutional perspective. And also mentioned that the Constitutional Court mentioned about the individual check, the obligation to check individually deprivation of citizenship will also matter, and is most probably going toward the direction that the Constitutional Court may, in the spring of next year, say it's not possible to deprive people from their birthright citizenship.
Well, I hope you enjoyed part one of my interview with Mr. Arturo Grasso. He was once again very generous with his time, and our interview lasted for over an hour and a half, so there's still a lot more to come. Now, I'm going to break the interview up as I did last time to keep each episode at a reasonable length. In the upcoming installments, we'll be discussing Mr. Grasso's thoughts on the upcoming Constitutional Court review of the June 25th Turing case, as well as the Supreme Court's planned examination of the minor issue. And we'll be taking a look at the future of recognition of Italian citizenship by descent. And as you heard him say at the end of the interview, he does believe that it's definitely possible that the new law, after facing all of the legal and constitutional challenges, could wind up only applying to people born after the March 28th deadline. Now, I've heard this from other top attorneys as well, and one thing most of the top Italian attorneys are in agreement on is that those who are currently blocked by the new law should strongly consider gathering all of the required documents to be ready in the event that things do change and a window of opportunity does open. Now, some have proposed that this window of opportunity could be limited in time, and even if it is open indefinitely, there could potentially be many thousands of people around the world all trying to file their cases at the same time if the Constitutional Court or the Supreme Court renders a positive decision. Those who have their documents ready to go could be a good 6 to 12 months ahead of those who are going to sit back and wait and see what happens before they start gathering their documents. Those of you who do qualify under the new law may also want to consider moving forward with applying or filing now as well. And if you would like some help navigating all of these complex law changes and understanding your eligibility, I do offer affordable 20, 30, and 60-minute consultations where we can discuss the specific details of your case and map out your best path forward. Now, you can book a one-on-one consultation with me at italianduel.com. I look forward to speaking with you, and I'll see you in the next video.